generate a thumbnail after it's been on, so don't worry about that. So if you click, and that's your URL.
Oh, there.
Yeah. So we need that to happen.
Mic's open. Right.
Good afternoon and welcome to this Jisc Legal webcast on the copyright changes that we're going to see hopefully on the 1st of June, all going well with the parliamentary process. We've been waiting quite some time for these regulations, and I'm sure most of you have been keeping up to date with the machinations of the parliamentary process and perhaps felt some frustrations over it. We've been trying to make sense of what has gone through Parliament, and hopefully we'll provide you with some practical guidance that you can pass on to your staff, the people you support in your institution. At Jisc Legal, we handle many inquiries, and you may know that over half of our inquiries are in fact to do with copyright. And so we know only too well the significance of copyright in teaching and learning, research and administration in colleges, universities and other learning providers. So today we're offering this masterclass to try and provide some answers. We also have a series of webinars on Friday, on Tuesday and on Thursday designed for frontline staff. The session is repeated 3 times. And so if you're trying to get the majority of your staff up to speed on what is happening, then you might point them in the direction of Jisc Legal for those sessions. Further details are available on the Jisc Legal website. Those sessions will be recorded, and this session is being recorded and will be made available in due course too. Also, in order to help you out, we have just finished completing an up-to-date copyright online training package. And we're just waiting for a few of the technical going online things to be done, and that should be available later on this afternoon from the Jisc Legal website. If you visit the website, you'll see a news story, and if you go to the training tab, you'll see the link will appear from there. The idea is that it will take frontline staff up to an awareness of copyright in somewhere between half an hour and an hour, covering the main questions, the frequent questions that come up. We are also going to produce and update our materials on the Jisc Legal website, and we've been busy working away at that. You will probably know that Parliament hasn't given us an awful lot of time to consider the final text of these regulations, but we've been working hard at it, and we will be producing those over the next few weeks. Today's webcast is live, and we do it live for a reason, and that's so that we can get questions in from you and you can participate in today's session. So we urge you that on the page that you're currently viewing, you should see a link to ask questions, and you can do that either by emailing us or by clicking on the button for the web form, which will open in a separate window and will not interrupt your viewing of the stream. You can also use the Twitter tag #copyright2014webcast, all one word, copyright2014webcast. And again, our trusty members of staff in the office will pass on the questions to us here in the studio, and we will answer them as best we can. To go briefly through the programme for this afternoon, which hopefully you'll see on the screen there, after this introduction we'll give you a quick overview of the provisions in the background. We will then move on to looking at some depth at the education provisions and the research provisions first of all, with a short recap video at the end of that. We'll then move on to deal with libraries and archives, again very important for the education sectors. At 2:50 we will have our first Ask the Panel session, where your questions, we will try and answer them here in the studio. At 3 o'clock we will give you a little bit of a break to digest and cogitate and to meet your caffeine addiction with a coffee break until 3:05. After the break we will deal with the disability provisions and the improvements made as a result of these regulations. At 3:15 we'll move on to look very briefly at parody and private copying, which you probably know have been withdrawn from Parliament, and so we'll be looking at it just in very a brief overview as to what sort of things would have happened and what might come back in future. And likewise we'll look at the quotation part as well, as part of the education section. Finally, at 3:20 we will have our second Ask the Panel session, where you can put your questions again live to the staff here at Jisc Legal. At 3:25 we will have a video on the top 5 things to tell your lecturers. If you are a member of staff supporting others in your institution, we hope you'll be able to use that video to bring people up to speed with the most important changes that have happened. And finally, between 3:30 and the close, we'll have the final roundup with drawing out from today's proceedings what are the main points of ambiguity perhaps, what are the most major impacts of the changes, what needs to be done now in terms of institutions. We value your feedback as well, so at the end of the day you see there's a feedback link. We would very much value if you could fill in that brief form, and to give an incentive for 2 lucky participants who complete the feedback form, we will be offering £50 Amazon vouchers. So if you didn't see a reason beforehand, hopefully that will give you the incentive to go on and give us the feedback. We do value it an awful lot. As I mentioned, there's probably been some frustration at the parliamentary process and we haven't had all the things that we wanted in terms of copyright. Nonetheless, these changes are fairly important and are certainly the most significant changes since 2003. So we hope they bring some of the educational provisions a little bit up to date and help us out in some way. That said, it's clear that these regulations are a result of some fairly heavy lobbying from both sides and represent a compromise between 2 sides. As such, there is still an awful lot of interpretation to be done, an awful lot of unpicking, and hopefully we'll take you through that today. So please do get in touch. If you want to give us a hello and tell us about where you are and maybe about your role, what you hope to get from today, then feel free to use the email, the web form, or indeed use the Twitter hashtag and say hello to us and just drop us a hello, that's fine. And especially if we've got multiple people watching at your end, then it's handy for us to know how many people are out there and making use of our webcast today. We're now going to show you a brief overview of the forthcoming changes. So here is Jisc Legal's quick guide to the regulations. Copyright changes. A quick guide. Following a series of government reviews of the UK intellectual property law regime, 5 sets of regulations were recently laid before Parliament. They represented a desire to modernise the UK statutory copyright exceptions in order to assist creative industry. But the resulting draft regulations were a compromise between the vigorous assertions of rights holders and licensing bodies on the one hand, and users on the other. The UK was also constrained by international treaty and its membership of the European Union in relation to permissible copyright exceptions. Of the 5 sets of regulations, subject to royal assent, 3 have passed into law. 1 on research, education, libraries and archives, 1 on disability, and 1 on public administration. We'll be considering the first 2 here today, which would make significant amendments to the Copyright Designs and Patents Act 1988 on the 1st of June. The Copyright and Public Administration regulations don't have a significant impact for UK colleges, universities and other learning providers, and will not therefore be considered today. 2 proposed regulations, one on quotation and parody and the other on personal copies for private use, were withdrawn from the parliamentary process for reconsideration following House of Lords committee scrutiny. At the moment, we have no indication as to if or when these might be reintroduced. Although amendments permitting quotation and parody would be useful to the education sectors, we will not consider them in depth today due to the uncertainty as to their future. These changes are taking place in the context of other changes. At a high level, the European Union is undertaking review of its treatment of copyright law, and the recent Marrakesh Treaty, administered by WIPO, the World Intellectual Property Organization, may see further changes in terms of disability and copyright. On a more immediate level, implementation of European law on orphan works and on public sector information duties is currently underway at the UK government level. As always, legislation is subject to interpretation, and the current changes are no different. Today we will offer our take on the regulations to allow you to make informed decisions when it comes to copyright in teaching and learning. However, we cannot take risk decisions on your behalf. The regulations. The 2 regulations we will be considering in detail today are the Copyright and Rights in Performances, Research, Education, Libraries and Archives Regulations 2014 and the Copyright and Rights in Performances, Disability Regulations 2014. Both of these will amend the Copyright Designs and Patents Act 1988, subject to them completing parliamentary procedure. Some general points about the regulations. This quick guide will consider, first of all, the extension of exceptions across a wider range of formats. Secondly, more fair dealing exceptions. Thirdly, availability of licenses as a restriction to certain of the exceptions. Fourthly, unenforceability of contrary contract terms. And fifthly, bringing performance rights into line. Extension to range of formats. In many of the exceptions, the limitation on the types of copyright work which are subject to the exception have been removed. So for example, Section 29, Fair Dealing for Non-Commercial Research and Private Study, is no longer limited to literary, dramatic, musical or artistic work. This is a recognition of the digital age and the multimedia world. More fair dealing exceptions. Particularly the introduction of Section 32, Illustration for Instruction. Fair dealing involves a judgment to be made. There are no black and white rules. There are a number of factors which might be considered, however. So for example, how much of a work is being used? Can less be used to achieve the same purpose? In what context is the use? The work will be made available to how many people and for how long? And what effect might it have on the commercial exploitation of the work? Availability of licenses. A number of the new exceptions contain restrictions that state if licenses are available authorising the acts in question, then the exception cannot be used. There will be a difference here between non-authorisation of an act and authorisation of an act subject to a condition. The exceptions no longer refer to licensing schemes authorised by the Secretary of State. Contrary contract terms. These are often a cause of uncertainty. So for example, many DVDs contain the restriction for domestic use only. And there's the question of how this affects Section 34.2, playing of a film. In many cases, contrary contract terms will be unenforceable. Performance rights. Many of the changes involve extension of exceptions to recordings. This raises questions of performance rights. Schedule 2 is amended to be similar to the relevant copyright provisions. An overview of the changes. Research and education. Libraries and archives. Disability. The two areas that have not gone through Parliament, quotation and parody, and personal copying for private use, will not be considered in depth today. Research and education. Section 29, Fair Dealing for Non-Commercial Research and Private Study, is extended. Section 29A, Text and Data Mining, is introduced. Section 32, Fair Dealing Illustration for Instruction, is introduced, and the exam provision is incorporated. Research and education. Section 35 provides for recording of broadcasts, permitting off-campus access by secure electronic network. Section 36 allows copying and use of extracts and is extended to all copyright works, and limits are increased. Libraries and archives. Section 40B, works available via dedicated terminals, provision introduced. Section 41, copying for other libraries, extended to other copyright works. Section 42, copying to preserve or replace, extended to other copyright works, and is improved. Libraries and archives. Section 42A, copying from published works is extended, and some improvements are made. So for example, it is clear that electronic declarations will now be acceptable. Section 43, copying from unpublished works, also extended to different types of copyright works, and also improved in terms of electronic declarations. Section 41 and Section 75 have updated the provisions with regards to folk songs and broadcasts. Disability. Section 31A to 31F are amended. This now includes all disabilities affecting use of the copyright work and is no longer limited to visual impairment. The provision is extended to all copyright works, and a license is required only if on reasonable terms.
Hopefully that video has given you an overview of the new regulations. We're now going to look at these in a bit more detail, and we're going to start off with the research and education provisions. And to answer questions on that regulation, I'm joined by John Kelly and Deborah Ferns from Jisc Legal. So let's make a start. Deborah, how do the copyright changes help researchers?
Well, fair dealing with a work for the purposes of non-commercial research and private study has been extended to cover all types of copyright works. So researchers can now copy short extracts from sound recordings, films and broadcasts, which they couldn't do before. And an advantage in these provisions is that they'll be able to make these copies irrespective of contract or license terms which apply to the work, because the exception can't be overridden by contract.
Okay, thanks. And I suppose on that subject, I hear there's a new exception to enable use of text and data mining technologies. What could you tell us about that?
That's correct. A new Section 29A will enable UK researchers to copy a work in order to analyse it using text and data mining technologies without risk of infringement. The exception applies where the analysis is for non-commercial research purposes, but you must remember that the person who's making the copy and doing the analysis must have a lawful copy of the work, so they must have lawful access to the work already in order to do this.
So that'd be a library copy, or the library having a copy?
It could be a library copy. So if you wanted to do text and data analysis of journal articles, for example, then and you could only access them via subscription, your library would still have to have that subscription. But it's also important to note that contract terms can't override the data mining provisions. So if this is a big advantage, because researchers no longer need to look at the license terms for every single work they want to data mine, because if the license says data mining is forbidden, it can't override the exception, so those restrictions in the contract will be unenforceable.
And the researcher can go ahead and use it in the way they want.
Yes, they
That's
can.
very useful, but they need to have a lawful access in the first place.
Yes.
Yeah. Okay, let's have a look now at teaching and learning. I'll stick with you, Deborah, if that's okay. Can I copy any work for teaching purposes?
Well, under the revisions to Section 32, it's now possible to copy all types of copyright work for the sole purpose of illustration for instruction. So lecturers can now use extracts from films, sound recordings and broadcasts, as well as text, music and artistic works. And copying is no longer restricted to being done by hand, so they can now take advantage of digital technologies such as interactive whiteboards. It's important though to remember that it's a fair dealing exception, so you can only copy as much as would be necessary for the purpose and would be fair to the rights holders.
Okay. Could you give an example maybe of how, you know, if an example of that working, something being used for illustration for instruction? Can you give maybe an example to illustrate that point?
Well, at the moment it's possible for a lecturer to show a clip from a DVD in the classroom, but they're not able to make copies of the DVD and put it into their PowerPoint presentation. So now, because there's no restriction on the type of work covered and you can do copies by a reprographic process, it's now possible to put a clip of the DVD, provided it's for illustration for instruction, within your PowerPoint, and then put that in the VLE and make it available to your students.
So could I copy the whole DVD?
You'd have difficulty to copy the whole DVD because then you're looking at whether that's fair. Is that fair to the rights holder? Really, that's competing with the commercial market for the DVD, so you couldn't copy the whole DVD.
Yeah, the illustration for instruction exception does have to comply with the fair dealing limitation. Isn't that right? That's fair to say.
And as you've come in, John,
thank you.
If I've copied part of a work, and I've used it I've embedded it, say, in my PowerPoint presentations part of teaching, can I now put that on the VLE, for example?
Well, the short answer is yes, with the same limitations that it has to be illustration for instruction. And if that remains, then the same test has to be applied to it. Maybe wider than that, you do have to see who the audience is, and that will also, I suppose, go into the test you have to apply of fair dealing. And that's part of assessing fairness in the fair dealing.
Okay. Quite a key one for us, this one. Deborah, what about examination? Can I still copy works for use in an exam?
In short, yes, you can, but examination's no longer a standalone provision. It's now incorporated within instruction. So you now have to think about fair dealing, which you didn't have to before. You used to be able to do anything for the purposes of examination. Now you have to think about whether what you're copying, the amount you're copying, is fair to the rights holder.
So it's maybe narrowed it
So
a bit,
it's possibly narrower. You're unlikely now to maybe be able to copy a whole work that you might have been previously been able to justify. But one advantage that there is in the new provisions is that there used to be a restriction on copying printed music for performance in an exam. Now you can do that, but obviously you still have to take into account fair dealing. So you might not be able to copy an entire symphony for performance in an exam, but a small part of a musical work could be copied.
Okay. And you talked about illustration for instruction. What about copying extracts of works? Is that different to section 32?
There's a separate section in the Act for making reprographic copies for an educational institution, and the way that differs from illustration for instruction is illustration for instruction can be used by anyone provided they are doing instruction. Section 32 is limited to being done by educational establishments. But Section 36, which is about reprographic copying, has also been amended in the Act and improved in some ways. The amount that can be copied has been increased to 5% per annum, and which is an advantage. And so if you're weighing up the two provisions, if you want to decide whether should I be relying on section 32, should I be relying on section 36, you need to think about what type of work you're using. In some cases, using the reprographic copying provision will allow you to copy more than you might have been able to under fair dealing.
But it may be the other way
But
round,
it may be for other
yeah.
works, it might be the section 36 you'd be relying on. But remember, you don't have to, when you're making the copy, you don't have to specify this is the provision I'm relying on. You just need to be confident that one of these provisions apply, and you would only in the case of a dispute would you then have to then justify which provision you're using.
In my mind, it's more live teaching is section 32, where it's in a lecture environment, whereas maybe more prepared online or VLE type content that you're constructing, you tend to use 36. That's the way I see it.
And is it 32 that doesn't have to be an educational establishment? So a work-based learner, for example, and so on. So that's quite useful. Yeah. So you've mentioned about percentages and copying and reprographic copying and so on. So will it still be necessary to hold licenses such as the CLA license then?
The short answer is yes, because unfortunately to rely on the section 36 provisions, it only applies for works that are not covered by a license which is available and which an institution should have been aware of. Right. So if a work's covered by the CLA license, in order to copy it, you would have to continue to hold the license. You couldn't rely on the exception. The exception would only allow you to make the copies for works that aren't covered by that license.
And the terminology is a license.
And the terminology that's used is a license. It doesn't specifically mention the CLA license, nor does it mention specifically licenses that are restricted to educational establishments. It talks about a license being available for the work.
So if there's a license in place, we have to use it. That's really what you're saying for that purpose.
Yeah. Okay. And it's my understanding the law has been changed with the new changes to allow broadcasts to be made available off campus. Can you tell us a bit more about that,
Yes.
John?
The exception has been, I think Section 35 has been extended to include off-campus use of broadcasts. But the same or a similar restriction applies in that if there's a license, in this case we're familiar with the ERA license, then you have to use the ERA license. But if, or in fact the ERA plus license to be exact. But for non-ERA content, yes, you can record the broadcast, use the broadcast, and which would include using it to students off campus.
Okay.
Non-ERA content.
Thanks. So it's not going to cover a lot of these works that you'll be dealing with will obviously be covered by the licence. It's not a kind of way
and I know the ERA are adjusting their terms and all that, but that's maybe a talk for another day.
Yes, I think so. We wouldn't have time for that one, I don't think. Okay. As the current law refers to teaching of film and film soundtrack making. So do the new exceptions affect that at all, Deborah?
They do. The way Section 32 has been amended is to remove the specific provisions in the Act for teaching of film soundtrack making and filmmaking. So if you're wanting to use a work for that purpose, you have to rely on the general exception for illustration for instruction. Right. So you now have to think about fair dealing. You wouldn't, which in practice means you're likely to be able to copy less of a work. You may not be, whereas you might have been able to rely on the previous provision to copy a whole film for film students. You can't do that anymore because you'll need to think about fair dealing.
Okay, so it's been narrowed potentially.
So potentially it's been narrowed.
Okay, John, I think the last question we've got time for. We've heard the new, from the video prior to this, we've heard that the new quotation exception is on hold. If it comes into force, what will it allow colleges and universities to do?
Well, there has been, and there is no lawful way to quote traditionally in the UK, and this introduces would introduce the right to quote a portion of a work. Again, it's fair dealing, but you have to use no more than would be required for the specific purpose that you're using it. So that would be the quote again. You have to be, if you deal with the extract you're using and the quote you're using fair dealing, and it has to relate to the work you're doing in its context. And you can be no more than that. But so you can't use large quotes. Sorry,
although that's postponed if it's going to come through at all, we've obviously still got the exception we're all familiar with, this criticism or review exception. So that's not going anywhere. This is adding to that.
That's correct. The existing provisions for using content for the purpose of criticism and review remain and will remain even when when and if the quotation exception comes into force.
Okay. So if the quotation exception comes into force, does it allow you to quote for other purposes than criticism and review?
That's correct.
So it's
there's no the quotation exception doesn't specify what you're using it for.
Right. Okay.
Whereas criticism review obviously has a very, I suppose, a well teased out meaning now that we know where we
specific purpose.
It's a phrase we're familiar with and understand.
Okay. I think we're on a bit of a tight schedule, so thanks very much. That was really useful, and hopefully our viewers got quite a lot out of that. Remember, you can still send questions into us for the panel discussion times that Jason mentioned earlier. We're now going to hear a summary, if you like, of the key points.
Copyright changes, research and education. The new copyright changes help researchers. Fair dealing with a work for the purposes of non-commercial research and private study will cover all types of copyright works, so researchers can copy short extracts from sound recordings, films and broadcasts which they couldn't before. The right to use this exception cannot be overridden by contract. A new exception will enable UK researchers to copy a work in order to analyse it using text and data mining technologies without risk of infringement. The exception applies where the analysis is for the purpose of non-commercial research. The person relying on the exception must already have lawful access to the particular copyright work, such as access via their university's library subscriptions. The changes provide greater flexibility for teaching. All types of copyright work can be copied for the sole purpose of illustration for instruction, so lecturers will be able to use extracts from films, sound recordings and broadcasts, as well as text, music and artistic works to illustrate a teaching point. Illustration for instruction. Copying is no longer restricted to being done by hand, so staff and students will be able to copy using digital technology such as interactive whiteboards. Before, you could do this. Now you can do this. But remember, the illustration for instruction exception is subject to fair dealing, which means copying is likely to be restricted to a small portion rather than the whole of a work. The right to use this exception cannot be overridden by contract. Examination now falls within instruction and is subject to fair dealing. Under the new law, you must consider whether use of the work is fair, which in practice may mean limiting copying to shorter extracts of a work.
Access can now be provided to recordings of broadcasts off campus by secure means such as the VLE. But this only applies to recordings not covered by a licence scheme, so institutions will still be expected to purchase the ERA licence for the vast majority of broadcasts. A licence scheme no longer requires to be certified by the Secretary of State. The exception which allows colleges and universities to make reprographic copies of extracts of works is extended to cover all works other than a broadcast or an artistic work, which is not incorporated into another work, and the amount of a work which can be copied is increased. But this only applies where there is no applicable licence scheme. So, where a work is covered by the CLA licence, universities and colleges will still be required to hold a CLA licence for copying. Licence schemes cannot restrict the proportion of a work which can be copied to less than allowed under the exception. Fair dealing with quotation has been delayed.
Now, in this section, we're going to deal with the new libraries and archives provisions, and we're joined once again by Jackie Milne, who's been looking into this for us, and is going to will respond to some of the questions that we think are relevant. And we'll kick off with Jackie. What are the main changes and benefits that have come out of the new law, in your view?
Okay, firstly, it simplifies things to some extent. It is a long regulation because of course it's addressing recordings of performances as well as copying. It incorporates what was or what is at the moment separate regulations, the librarian and archivist regulations. Yeah. It also consolidates sections, so 38 and 39 become one. So I think it does simplify things. Probably the big and the most beneficial thing or positive thing is that in line with fair dealing and other provisions that are coming in, it will apply to all works.
All right. Right.
So that's really a big plus. If you're an archivist and you want to preserve a work, you were previously restricted to particular works. You would then have to trace the copyright holder and get permission, which we know is costly, time consuming and all the rest of it. So this is a real plus. It also provides clarity. So in most cases, which has been mentioned already. I think Deborah talked a wee bit about this kind of tension between the application of the exception and a contract. And in most cases, the contract will not override the exception. So that's useful to know. In terms of providing copies of unpublished works, of course, you're still subject to any prohibition in copying by the copyright holder. But overall, exceptions will override contracts. There's also a bit less bureaucracy, which is always good news.
Yes.
Declarations are still required, written declarations, but these can be in electronic form, digital form, and by the absence of the word signed, we can infer they don't need to be signed, whereas
so there
at
was
the
a
moment,
digital signature, requirement.
at the moment they did need to be signed. So these thousands of pieces of paper you have in your filing cabinet, maybe that's going to make things a wee bit easier for librarians and archivists.
And you envisage that being done as an online form? Or online?
Yeah, maybe if you've got a researcher, for example, overseas they can now email the form to you. That should be sufficient. You've still got to cover the same ground, as it were, but the format's making things a wee bit easier, hopefully.
Right. In terms of the exception itself, what can a librarian do now that they couldn't do before? I suppose that's I'd like to get it in that context.
Yeah. Well, as I said, we're now talking about all works, so that has obvious benefits. You will still be subject to the kind of same old suspects. For preservation, it's permanent collection. You're only allowed to make certain copies, certain parts of work, single copying, all that kind of is still in place. But I suppose that there is good news for if you're making a preservation copy, you're now able to make more than one. You can make as many as you want for that. So that's something that couldn't happen before.
So I'll be able to copy more types of works and more of the work. Is that right? Is that what you're telling me?
Okay, there's a yes and a no there. Yes to all types of works. It's going to cover more types of work, any work, in other words, but not necessarily more than that. As I mentioned, yes, you're still going to be subject to this single copying, so multiple copying still out. You'll be able to copy parts or whole of a work depending on who you're copying for. You're still subject to non-commercial use, private study, and so on. But for published works, they've changed terminology. It used to be a part of a published work, and they're now using the phrase a reasonable proportion.
Is that not the same as a part? No, that sounds to me very like the same
Well,
as a
it
part.
could be the same, but I suppose there might be an argument that a part could be 1%, whereas a reasonable proportion is likely to be greater, depending on if your glass is half full or empty.
So that has to be all worked out. There's nobody telling us what that is.
No,
yet.
we don't know
Right.
exactly what that means. There's no definition of that. And as I mentioned, preservation copies, you can have more than one copy.
And for will there be increased access to archived materials? I know that was one of the intentions of the legislation to get us to the stage where this stuff that's all hidden, we can now access it. Is that part? How does that fit in there?
Okay. Potentially, yes, if you can take advantage of the new exception, which talks about providing or communicating or making available works to the public via dedicated terminals, then that's an example where perhaps you would be increasing access. But apart from that, you're still, for example, for preservation, you're still going to be subject to the permanent collection, which may provide access, which may not, but that's not going to be increased as a result of this new law.
But you can still make copies, isn't that what you said? Of the permanent collection.
Provided it's for the purpose of preservation.
Preservation, okay,
Yes.
just to get that clear in my head.
Yeah.
So, and I know there was talk about forms, but what actually is, for example, the obligation on the library to make sure what's being done by someone coming in using it isn't commercial? What I know it says non-commercial use, but what is the library supposed to do to police that, I suppose?
Well, currently the library must make sure that they receive a declaration when they're providing a copy for an individual. That doesn't go anywhere. The declaration is still required. In other words, it's going to cover the same ground about non-commercial research, private study and so on. But that was really to cover the librarian, if you like. In other words, if somebody put something down that was false, it wasn't for non-commercial research, it was the individual who actually signed the declaration rather than the person who carried out the copying. So that's quite good, that's still there for that purpose. But going back to this new exception, there's no declaration required for that. So this making works available to the public or communicating to the public these works via these dedicated terminals, you don't need a declaration for that.
The library doesn't have to have a declaration
No,
for that.
and further, the purpose is for research or private study. There's no non-commercial in there, the inference being that commercial would be permitted. So it gives you a bit less of a kind of onerous vetting obligation on the librarian.
So the dedicated terminal gives access to what material, though? Remind me again what material is. How do I can't just give anybody access on a dedicated terminal to my collections, can I? Is that what you're telling me?
Well, you can make available or communicate a work to the public via this dedicated terminal, but there are certain conditions associated with that, as always.
Yes.
So you need to have a lawful copy. As I mentioned, you also need to, it needs to be for purposes of research or private study, but remember it doesn't say non-commercial.
Right.
And the big drawback here is you're subject to licence. So if the licence says you can't make it available in that way, then there's no get out, there's no override of the exception.
And it has to be on campus, this terminal?
It has to be on the premises. It doesn't have to be in the library, but it needs to be on the premises.
Right. Okay. Very good. Well, that's a very quick run through the libraries and archives provisions, and I know that there's a lot more will come out of that as we all get to grasp that exception when it comes into force on the 1st of June. We'd like to now to go to a short summary of that provision, if we can.
In summary then, the new regulations repeal the library and archivist regulations, making changes to relevant sections in the Copyright Designs and Patents Act, address rights and performances, and add an entirely new exception for dedicated terminals. This entirely new exception specifically refers to educational establishments and allows digitised works to be viewed on the premises via dedicated terminals. Use is restricted to private study or research, so this will include commercial research. Communicating the work or making it available in this way will, however, have to comply with any licence attached, so the librarian or archivist will still have to refer to any contract pertaining to the work. Section 41 provides the same restrictions as the current law, but to ensure consistency, it will also extend to all types of work. Any contract term limiting the exception will be unenforceable. The new exceptions for archiving and preservation are made broader so that libraries, archives and museums can preserve all types of work. The exception will still be limited to reasonable copies, i.e. to preserve or replace items that are part of a permanent collection. Again, any restriction contained in a contract will not override it. For published works, copying will be limited to a single copy or a reasonable proportion of any published work for non-commercial research or private study. Written declarations are still required but can be in a digital format. Importantly, the extent of any contract term preventing or restricting the exception will be unenforceable. Libraries will be able to copy a single copy of the whole or part of an unpublished work for non-commercial research or private study. Again, a declaration is required, but can be digital. However, this exception is still subject to the wishes of the copyright holder, and where prohibited, will be overridden. And finally, any archive not established for profit will be able to record folk songs and broadcasts for archiving and preservation purposes. They will no longer need to be officially designated.
Well, welcome back to the studio. You've been hitting us thick and fast with questions, and we've been doing our best to digest them, and they're coming in here to the studio, and I'm going to put them to our experts so far. My first question is for you, Deborah. We've been asked, Regulation 4 substitutes new sections 32, 35 and 36 and relating to education. The question is whether the non-reprographic or reprographic copying elements have been removed from these sections.
The answer to that question is yes. The illustration for instruction section no longer refers to reprographic copying, so you can not only copy by hand now, you can use digital technologies to copy. And the section 36, which referred to reprographic copying, just talks about copying extracts from works. So we know there's no longer a distinction between the two in terms of the means you use to copy the work.
That's quite welcome in an age where it's no longer talk and chalk.
And reprographic meant any machine. Is that really what I think it was? Wasn't it like anything that's not
any facsimile copy?
Facsimile or photocopying.
Yes,
is
photocopying.
The kind of traditional interpretation of
but
it.
now presumably includes other technologies like whiteboards and
Indeed.
all of that.
Okay, sticking on the subject of teaching and learning, one of our most common questions here at Just Legal concerns the use of images and presentations in teaching and learning. Can you outline how the situation is improving, if at all, as a result of these changes?
Well, I think that when a lecturer or a teacher fits within the exception of illustration for instruction, then they can use, there are limitations of what they can do, but they can use content including images or any other work. And I don't think it restricts the work, as I understand it. But you are restricted by fair dealing. So when a lecturer or a teacher decides they want to include a piece of a work in their work, in their teaching, it has to satisfy this, as I said, this test of illustration for instruction. It has to obviously relate to what they're teaching. It has to illustrate that. And it has to be fair to the rights holder. I think that's just really what that ultimately means. And if it satisfies these tests, then the teacher can use this in their teaching.
I think one of the factors, when it comes to images, I mean, obviously we've been talking a lot about it being fair, where you take a short extract of a work. It's quite difficult sometimes if you're talking about a whole image. But if you think about what the market is for that work, is this image in your PowerPoint a replacement for the original work? Is maybe a factor to take into account, and also the resolution in the images. I think lower resolution images could be more likely to be deemed fair.
So I would say that taking the copyright notice and watermark off a commercial image bank photo to use on a PowerPoint slide would not be a good idea.
No, I think it's risky.
And you also mentioned, I think before, that the audience, who the audience is, or how wide the audience is, and what you're going to do with it at that stage, whether it's going to be retained and used in the VLE or put on a website, all that sort of stuff is going to work against you if you're going to try and establish that that's fair dealing.
So you'd have password protection measures and things like that.
Yeah, to protect it.
Jackie, coming to yourself, I think there's a question you've dealt with before with regards to Section 40B and the question about, I've been asked whether it means non-commercial research. That's or commercial research. Do you have a view on that?
I do have a view. I'm not sure how accurate it is, but my reading of the section is, it states research or private study, and in every other case they've obviously, in drafting it, used the term non-commercial, so to me it's omitted for a reason, and therefore the inference is it can be commercial.
Okay, thank you very much. Well, the wording is clear in the and I'll follow on by asking, we've been asked with regards to offering through dedicated terminals, Does that mean that an institution can digitise content from commercial DVDs and videos that they own and that are currently available for viewing within the library and make these available via a streaming service? Or does that have to be limited to certain machines as dedicated terminals? Or is this going to be a complex question depending on licenses and rights?
Yes, this is going to be a complex question, and I think it's likely to go back to what the licence says you can do. If there is no licence, which I doubt, then obviously you can take advantage of the exception, but you're limited to terminals on the premises. So I don't think it would prevent you streaming it, as provided that it's accessible on the premises. But remember, this is not just for students or lecturers, this is for any member of the public.
Would this section allow the scan to be made in the first place?
Again, it's down to interpretation. The section has been taken directly from the copyright directive. There's been no addition to the text, so it's not that helpful. It doesn't really tell us the answer in short. There's an ongoing case, the Darmstadt case, which went all the way to the German Supreme Court. It's now gone to the European Court of Justice to talk about, and there should be an opinion on the 5th of June, which isn't that helpful today. My feeling is that the wording is such that it says making available. So in order to make something available on the terminal, if you have to scan it, I think there's an argument that yes, it would allow that. But until we hear, for sure, we're kind of guessing a wee bit.
Okay. Coming back to the question about images then, as we know, is a perennial one, and images in teaching and learning. If I'm a lecturer and I find an image on a website that I'd like to use, do I have to take any steps to find out if it's licensed, or whether do I have to get in touch with the owner if I can find the owner and ask them whether they're willing to license it to me before I use it in teaching and learning?
That really depends on what provision you're wanting to justify your use under. Section 32, illustration for instruction, that exception overrides contract restrictions. So if there is a licence restricting your use of it in that way, that contract term's not valid because it's preventing you using the exception. So provided it's illustration for instruction and it's fair dealing with the work, then you would be able to make that copy.
But it's good practice, I suppose, to check the licence. I think we tell, I know this isn't relevant to the changes, but in our other work that we do, we're always telling people to check the licence, because in many cases there are licences.
Although we know in most cases right-clicking on an image, you're not unlikely to find a licence that relates to it. And I suppose then the availability of a licence is going to go to the question of fair dealing, even though it doesn't directly affect whether you can use Section 32. So
yes, so I mean, if it's quite clear there are licence restrictions and you have to purchase that image, then that might be a factor taken into account in deciding whether what you've done is fair dealing.
Yeah. Okay, thanks. We'll turn to the question of the use of broadcasts, which is growing in terms of education. And we have the question: does the ERA plus licence is that no longer required? Just the ERA, given these changes? I think we're aware of the fact that the ERA is moving to a single licence, so I think that's probably going to be the answer. So there's no longer going to be an ERA plus or an ERA licence. There will just be the ERA licence.
No, the exception, the relevant exception on broadcasts remains that if there's a licence in place, you can't use the exception. So it's worded in that way and phrased in that way. A whole different issue was, we talked about the fairness of the licence, or how the terms are agreed. But when there's a licence in place, then you have to use, as I said, we talked about ERA content. But for non-ERA content, then you can use the exception. And as we talked about, this provision extends that to use off campus.
And that's been a very common question, indeed one that's come into us here, so that's been very worthwhile. I'm going to take a step back because I know I can see from the questions here that there is the ongoing question as to when to use section 32 and when to use section 36. I know you touched on this, I think, Deborah, in your previous session. Again, would you care to reiterate what that is? What's the difference between 32 and section 36 for a lecturer who's just wanting to use some content in their teaching?
Okay. Well, section 32, it has to be it has to be illustration for instruction is the first issue, and your use has to be fair dealing with the work. The advantage you get from that section is that it, as I stated in relation to the question about images, as that exception overrides licenses. In section 36, which talks about reprographic copying, now it covers any work apart from a broadcast or a standalone artistic work. In that provision, how much of a work you can use is limited to 5% of a work in any 12-month period. And so, depending on the type of work, it may be that you can use more under the reprographic copying of extracts provisions than you might be able to use under fair dealing. But the point about section 36 is if there is a license scheme available for the work you want to use, then you have to use it. You have to hold the license in order to make the copy. So you can't do away with having a CLA license.
And the other point that was made earlier, I think, also is that it doesn't have to be instruction, non-commercial instruction. Isn't that right?
That's right. So if you're looking to use the section 32 provisions for illustration for instruction, if you're a work-based learner or another establishment giving instruction, then you can use that exception. You can't use section 36. Section 36 is limited to educational establishments and teaching staff within those establishments.
Do you think illustration for instruction is narrower than instruction?
I think only time will tell with some case law. I mean, at the moment there's no description of the difference, and in fact the way that the provision is described in section 32, the old section 32 never mentioned illustration, it mentioned instruction, and how the terms defined hasn't been changed. There's not been any additional definition that explains what we mean by illustration.
Perhaps another day we'll do the question as to whether decoration is sufficient decoration for instruction.
I think not. I think we're talking about how illustrating a teaching point, not prettying up your PowerPoint presentation.
Okay, so coming to the nitty-gritty then of it here, I suppose section 32 then has the advantage you don't need to look outside at all, you just need to consider whether your use is fair, so you can do that sitting at your desk. There's no searches or questions as to whether licenses exist or whether there's been any previous copying in your educational establishment. Then you can just take the decision provided you fall within that. Section 36, you mentioned the extent, which is now per educational establishment, is that?
Yes, it used to be talk about a percentage within a quarter. Now the language talks about not more than 5% of our work may be copied by or on behalf of an educational establishment in any period of 12 months. So this sounds like a bit more work for institutions. They need to look across the institution as to what copying has gone on, and they have to look at, on the date they're making the copy, what other things have been copied in the past 12 months, which to me sounds a bit more complicated than looking at a calendar year of January to December, or alternatively looking across the academic year.
So that's new, that's completely new, is it, that requirement to do that?
Indeed.
Yes, it was based on quarter by quarter previously, which was a bit more easy, I think, to manage.
So those copyright officers with us might be setting up a section 36 log of copying made as an activity after this. I'm going to put you on the spot here. Can you think of any works then that are coming down the nitty-gritty are going to be covered by section 36? Do we know of any works that aren't going to be covered by licence that are going to be in mainstream educational use in the UK? What sort of things are we talking about?
There are some specific works by specific publishers that are excluded from the CLA licence. Right. So those works, possibly you could rely on the exception. but then you do have to consider if there's maybe another license that covers that, because the terminology talks about a license being available for the work. It doesn't say the CLA license.
Okay.
So if there's another license scheme that covers a work, for example, by a US publisher, then they may need to consider that.
Okay. And if I'm going to use a US publisher who's or a non-included publisher for the CLA purposes, am I going to have to phone them up and ask them, do you have a license, or is that the sort of extent I'm going to?
I guess we don't know yet. It talks about a license scheme that the institution knows about or should have known about. So I guess it depends about, a license rather than a license scheme. It talks about a license that they should have known about.
Well, thank you very much. That brings us up to 3 o'clock, and we did promise you a coffee break before we come back at 3:05. Please continue to get your questions in. We will incorporate the questions into our guidance as we produce that over the next few weeks, and we'll try and respond to as many of them as we can in our later panel session, and indeed we'll try and respond via Twitter or to your emails. With that, I'll let you go to the coffee break, and we'll see you back at 3:05.
Welcome back to this Jisc Legal webcast on the new copyright changes. We hope you did get a bit of a break, and we'll be moving on, but I hope you haven't been checking your emails. That's the tip. We have another few minutes which we're going to deal with the changes, and in this session we're going to deal with the new disability provisions in particular. I'm joined by Betty Wilder from the Jisc Legal team, who's going to help us through it, help us understand it. For over 10 years, and for quite a while now, I think more than 10 years, there have been exceptions in copyright law which allowed us to adapt resources and make them available and accessible for disabled learners without having to get the permission of the copyright holder. The new Copyright and Rights and Performances Disability Regulations 2014 come into force on the 1st of June and update what can be done, and that's specifically what we're going to try and tease out here. So I'm going to ask Betty her first question on these. Do you think the new changes make it easier for an institution to make accessible copies for learners? Does it make it easier for them in your view?
I think that's probably the easiest question to answer. It's yes, they definitely do. They are an improvement on what has gone before. It now covers all works, all disabilities, and you can make lots of different types of adjustments now.
Right, so that you're not restricted to the type of adjustment you can make as well. Right,
absolutely.
And so the major changes, as you say, all disabilities, so particularly for a disability that does what?
Well, to be more precise, it's all disabilities that would affect your ability to access a work on the same basis as somebody who doesn't have the disability could access it. So we're now talking about things like the deaf and the also dyslexia. Now, in fact, although copying, has been done for those, and access has been changed.
Dyslexia was always
it was actually always excluded. The previous law only applied to the visually impaired, so this is most definitely a step forward, bringing it more in line, I would say, with the Equality Act definition of disability. So it's definitely moving in the right direction.
Right. So the exception will enable the institution to make copies for a learner, presumably staff member as well. It doesn't have to be a learner,
exactly.
Do they? Anyone.
Yep.
As long as the adjustment or the change makes it more accessible to them. Or they require that?
Yes, they need to have they can make more or less any change they like, provided it is to help make the work accessible to the particular and to suit the particular disability of the learner.
And obviously in this day and age, a lot of the works that are being used in teaching and learning will be things like multimedia type content,
absolutely,
DVDs and online materials.
And that is again where the new law it's a huge improvement, because it covers all works. And as we know, many learning resources these days, they are in a digital format, film, video clips, broadcasts, recordings of performances. All of these are now covered under these new provisions, and there were restrictions previously on whether they could be copied.
Learning modules, all that type of stuff.
Yep,
all right.
Exactly.
And when the institution buys its content, there are restrictions on. Says it's not, you're not allowed to copy it. What is it supposed to do?
Right. So you're talking about the other main new change, which is that very specifically for disability contract, it cannot override these provisions.
Right.
That if the contract makes it more restrictive than what the exception says you can do, the exception trumps the contract, basically.
Overrides it, okay.
Overrides
so,
it,
so the
absolutely.
institution, once it's lined up the fact that this person requires this, despite what it says on the instructions,
Yep,
the exception will apply. All right.
it will.
And again, another obstacle sometimes are digital rights tools that are applied to content,
Yep.
obviously by publishers to manage the resource
Yep.
in terms of how many times it's used, so that they can control all of that. How does that go to work for persons with needs with disabilities?
First of all the lobbying that was done, prior to the new law coming into place, it's been unsuccessful in this area. Digital rights management, basically the previous law, and that still applies. No real change there. However, there is something that should perhaps be tried, that if you do feel, institutions, as far as we are aware, there is a recourse. You can actually apply to the Secretary of State and get him to decide whether the work should be made available. But
is that
as
new,
far
or was that existing?
was in the previous legislation, but as far as we at Just Legal are aware, very few, if anybody, has actually tried that route.
We'd be interested in hearing from anyone who has gone down that route, indeed.
We certainly would. Yeah.
But it's not something that has changed, in fact.
No,
really.
basically circumventing digital rights management remains copyright infringement, is the bottom line on it.
So how will the changes affect licenses that institutions are buying usually? How does that
Well,
work?
I've had a look at a couple. We've said that, I know that I have said that the exception will override the contract or the license terms, but you do have to be careful. For example, at the moment, the CLA license is actually allows more than the law does, so it doesn't mean you can ignore your licenses. You still have to look at them, because you may find that the license is better than what the law is providing. Perhaps, say, on digital rights issue, it may improve things for you, may give you an out. The other one that I have looked at is the ERA license, and at the moment subtitling is not permitted under the ERA license.
Broadcast content, so content that the institution records on off-air, I think is the phrase, then you have to use that as it is. You can't apply subtitles. You cannot. Under the ERA license.
A college or a university cannot currently subtitle according to that license. However, that has all been removed, and a college and a university, those two, I'm being quite particular in that they are educational establishments and authorised bodies for the purpose of this, and so they will be able to to subtitle, which I think will again certainly improve things for the learner.
The other thing is, the last question we'll deal with is if there's an accessible version commercially available, how does that affect us? What are we supposed to do with that?
Well, you've still got to buy that, I'm afraid.
Right.
However, it has changed slightly, the wording has changed slightly. It has to be available to you at a reasonable cost.
License.
The cost of purchasing it has to be reasonable. So I would suggest that's maybe a future work for lawyers to decide what that means. Yep.
Okay,
so
let's
it's
not go
open
there.
for contention.
Thank you very much, Betty. That's been a very interesting little bit on the new disability provisions. We're going to go now to a quick summary of these disability provisions.
Copyright changes, disability. These new provisions improve the current law on making suitable copies of works for staff and students with accessibility needs. The provisions will apply to all disabilities affecting access to copyright works, and will cover all works, including film, broadcasts, video and sound recordings. For example, It will now be possible for a college or university, as an authorised body, to subtitle works for a disabled learner, and to make accessible copies of recordings of performances. However, it is not a free-for-all. Remember, if there is an accessible commercial version of the work available at a reasonable cost, this should be purchased. Also, the provisions regarding removing technological protections on works remain unchanged, in that this is still copyright infringement.
Okay, we're now going to have a look at caricature, parody and pastiche and private copying. And I'm joined again by John Kelly, who's going to provide us with all the answers. Okay, what are the changes that affect caricature, parody and pastiche?
Very good. Well, at the moment in UK law, if someone wants to use someone else's materials for the purposes of caricature, parody, or pastiche, then they need permission.
Yeah.
That's the existing law, and I think it's also, I know it has been mentioned, but these provisions aren't coming into effect. They've been delayed for further scrutiny by Parliament. So
it may well change.
Yeah, it may well change. But for the moment, at the moment, rather, the law is that if a comedian wants to use a few lines from a song or a film or for the purposes of their own work, they have to get permission. But the proposed changes are to allow limited use of copyright material for these purposes, and it'll have to be also fair dealing. So it's a significant change, but as I say, it is delayed.
So can you give us an example?
Well, I did give an example of a comedian using another person's work. It's a very common thing. I think we see it all the time on TV, where what I suppose is a caricature of someone else is used. Now there's a good question to be asked, and I know we have a prize for feedback. Maybe we should have had a prize for those who can tell the difference between caricature, parody or pastiche. But luckily I've got a definition which I'm going to read because I think it is very interesting. We do forget that these things go on. So a parody imitates a work for humorous or satirical effect. So commenting on the original work, its subject, author, style or some other target. So that's parody. A pastiche is a musical or other composition made up of selections from various sources, or one that imitates the style of another or other artist. So again, that's a pastiche. I don't think it's as common maybe as we would use. And again, a lot of these things, how relevant they are to the work in the education is probably limited. A caricature portrays a subject in a simplified or exaggerated way. I think maybe we're more familiar with that for those old enough to remember spitting images. That's the caricature. That's what that really means. And I mean, again, that can be insulting or it could be complimentary depending on how it's used, I suppose.
Yes. So I don't need a license then to use a work.
Well, no, you're still, if you're using a substantial part of it, or if you're using it in a large way, then you're going to need a license. So your use has to be fair and reasonable, and really you can only use a minor part of it. So I think we're applying the same fair dealing test to the use.
So in some of those examples you gave, we could be talking about use that's perhaps derogatory or distasteful or not very nice.
No,
so
that is true.
What happens in that case?
Well, the law of libel still applies to the use. So clearly, the copyright change which would allow you to use it doesn't allow you to use it in a way which would be libelous to someone else. So those anybody who would be liable in that way still has the right to go and defend their good name and their ownership. And also, this thing of derogatory treatment remains, so that there was always a moral right for one's work not to be treated in a derogatory manner, and that remains. That hasn't changed and won't change should this parody, caricature and pastiche exception come into force.
So it's still going to be unlawful to damage someone's reputation?
It's still damage. The author's reputation remains to be defended.
And as you mentioned, this regulation is not coming through 1st of June, so we're going to have to wait and see what happens with that. As well, obviously private copying is in that same situation. So just summarise very quickly what the changes are to making private copies for personal use.
Yes, this was one of the proposed changes that did get a lot of headline news. It was picked up in the popular press that something which was being done quite a lot. People were buying music mostly in one format and then buying it as a CD and then converting it to their MP3 player. And that was never, that wasn't lawful as such. There was no right to do that. It was in many cases a breach of a license. The proposed changes would have made that lawful. But as we said, that's not coming into place. So if you had bought a CD with particular content, or a DVD, didn't have to be music, or any other content, then you could make your own copy for your own personal use.
So does that mean I can let my children, my husband,
No, it has to be personal use, and this is part of the difficulty. I think this is part of the difficulty why the introduction of this provision was delayed, because it has been brought to the attention that there are, your family. Well, does it mean can your family use it? Your extended family. Lots of people have large families, and does it cover your cousins and all that sort of stuff? So that was part of the reason that I think that it has been delayed for further scrutiny. So no, it's for your own personal use. The copy would be made. That would have been the justification.
So can rights owners still protect their works?
Yes, of course. They can. All of the provisions to do with digital rights management and copy protection technologies remain in place and won't change, even if the exception is brought in at some stage under the existing version of the law as we have it. Okay. So no, that remains in place.
So what you're saying then is that a college or university can copy its entire collection of DVDs or CDs?
Absolutely not. No, I'm afraid that it's not good news, or wouldn't be good news even if it was coming into force for libraries in that sense, because that's not personal use. The notion would be that this format shifting would have been for the purposes of personal use. So if a library has a collection of CDs or DVDs they want to make copies of to distribute further, they need to have license permission.
Okay, good old licenses again. Okay, thanks for that, John. And we're now going to hear a summary of the key points. Copyright changes, parody and private copying. Caricature, parody and pastiche, in summary. Limited uses of copyright material for caricature, parody or pastiche would be permitted without the permission of the rights owner. Only minor uses would be permitted, and the use must be considered fair and reasonable. Change would not affect the right of the copyright owner to object to derogatory treatment of the work. Personal copies for private use, in summary. Consumers who have bought CDs, etc. would be able to copy the content from one device to another. Copying of music on a bought CD to an MP3 player would be permitted. Making copies for others would still be against the law. The work must be owned or have been acquired legally, and copyright protection technology still must be respected. Okay, welcome back. This is our Ask the Panel. You've had lots of questions coming into us. If we don't get round to your question, please don't think we're ignoring you. We are limited in time and we'll get back to you via email. Okay, let's start off. There's one, Betty, a disability question. The new provision for adapting video and other content for deaf students mentions subtitles but not BSL, meaning British Sign Language.
Yep.
Can we adapt content with InVision BSL? In the past, I believe adapted content was produced for an individual.
Well, the short and brief answer to that is yes, you can do it. You are now able to make a recording of a broadcast or of a performance. You are now able to adapt it to suit the particular needs of your students. And you can, you know, in my view, that would include keeping it secure. The adaptation that you have made, as long as it's not generally available to the public, it is being kept for your students and your students who particularly need it. Then I think that you could also store that on the VLE for the use of your students.
So it has to be for a particular individual who requires it. Is that still the requirement?
Yeah, or you would have a group of individuals
Okay.
that might require it in a particular college where they deal mainly with, say, deaf students. You would do it for the group.
And we're talking about British Sign. That's when there's almost a little separate window on screen where someone stands up and does that. Yeah. Okay.
So, I mean, that's obviously for a disability, for someone who requires it. So I think we have to make sure that's the case.
Right.
Yeah.
It doesn't extend to, for example, a college might decide to make an adaptation, have that available just per se. So if someone decided to click on it out of interest, they're not requiring that, so it should not actually be available to
Or
them.
it might be someone with a disability, but they don't require that particular.
Absolutely,
Okay.
absolutely.
And can we keep content and use it over and over again with different groups of deaf students? For example, adapting text with BSL and putting it on the VLE.
My view on this is that yes, you can, provided you have, you may already have a license for the work. You will have lawful use of the work. You are then adapting it to suit the student. You are then keeping it secure, or to suit a group of students. You're then keeping it secure on the VLE as your intermediate copy, perhaps, for use with other similarly students who similarly require it.
So once you've got that accessible copy, as provided you're not making it available to anyone, you can
Absolutely.
keep it until
Yep.
perhaps it's required. Okay, that's useful. Does the new regulation take account of my need to be proactive with regard to disability under the Equality Act, this proactive duty?
Right.
Well, it helps you fulfil that, I
Yes.
think. But
Doesn't mean you can
That's
break, but you can act unlawfully though, does it?
no, it
No.
doesn't. It's going to mean, it forms part of what you will do as an institution, how you will approach it. And I think it helps you enable it or provide it. So there's an anticipatory requirement, as we know. But how that works in practice will differ.
I don't
Will
think
vary.
thinking you may well have someone
No,
coming along
is enough.
is enough.
It's
to
not.
get to trigger the
But
exception.
if you have a student who has been there and you know that that student is now going into their second year, is now doing a different course, you could be proactive and have the course work
Yeah.
You should be provided.
prepared for them. You should be.
Okay, we've had quite a lot of questions about images.
Going back to using images, is that what you mean?
Yes, okay. This is quite a long one and it's referring to section 32 or 36 again. So, would including images such as photographs of works of art in a PowerPoint for instruction,
Illustration for instruction.
well,
yeah.
let's assume it's illustration for instruction, although it does say for instruction, so let's stick with that just now.
Alright.
for instruction and putting presentations on a VLE now be permissible under either section 32 or section 36? So I don't know if it's just for instruction, if we assume it's not meeting the illustration for instruction, obviously 32 is not going to apply.
Yeah.
But it's a bit ambiguous, so maybe it is meeting that.
Yeah. I think that, I mean, it still has to pass the fair dealing test. And that's always hard to prejudge about every image, because if we did talk about a lower resolution, perhaps copy, which would function to do the same thing. So you've got to establish that it is fair dealing. It's I know the real question is whether using all of the image is really going to be possible, because it's hard to see how, if you use all of the image, that's only part of it or a portion of it, or it's fair, because clearly one should be out there buying the real image, and it's hard. I can see where that balance comes, but I think it's fairly safe to say that if the teacher is, or the person generating the materials is using an image and it's for illustration, it's an important part of what they're doing. They're using a fairly low, not a high resolution version of it. It's used for if it satisfies that test, it's restricted, and then restricted to the VLE with login. Then there's a lot of people punting for that being the way the law is going to be interpreted. Now I'm not. I'm sitting on the fence as long as I can, but I think that's right. I think that's right on the money where the exception is aimed at. It's aimed at making that type of use of materials easier. And I think obviously calling it an image, putting an image in there becomes the tricky bit. It's easier to justify maybe using a portion of something, and the real difficulty is using the image. And I think that,
I think in the situation where it may very well remain technically copyright infringement, and it then comes down to risk as to whether it's used.
Whether an institution should go ahead and do that or not. Yeah.
'Cause
I think
of
the risk
course
will be lower where the resolution's low. It's justified under teaching and learning. And it doesn't matter whether it's section 32 or 36, that's not really the...
In other words, how can we possibly measure?
Yeah, it's hard to
the
prejudge
extent?
that.
Okay. Okay, as teachers, we can now use extracts from audio, video and text as illustration for instruction. Are we required to reference the source in our handouts on the VLE, or is this not necessary?
It's my understanding that sufficient acknowledgement is required.
Yes, I agree.
So that's a short answer to that one. But yes, so that term, sufficient acknowledgement, remains a requirement. And so again, it's a phrase we're all familiar with and understand, I think.
Okay. I think you've answered this already, perhaps, Betty. It's about the making copies of electronic resources under the disability provisions have to include any DRM associated with the resource. Do you need to worry about the DRM? There's no way to get around that?
There's no way to get around it, really. If you do, I not being a particular, as my colleagues will know, not being very hot on technology.
I wouldn't say that.
PDFs, I think, are very for example, you can technically protect them, but it's very easy to unprotect, for the layman to unprotect and then to make that PDF accessible for someone.
Yeah.
So what the law says, and which it has always has said, it said it in the previous provisions, is that you should then try to reinstate the measures
Protection,
into the new accessible copy. But where it is reasonable to do so now, in many instances that would then make it inaccessible again, or could do so. So it's a question of acting reasonably.
Okay, and I think I have to ask this one as regards MOOCs. Will the copyright exceptions, presumably the new ones, affect the use of third-party material in MOOCs? Well,
as I understand it, the MOOC is outside the general activity teaching of the university. I think it's possible that the Section 32 teaching exception could apply, but then is that multiple copying? So we're back in trouble again. What's your understanding of it? Do you remember?
I'm a bit cautious about that one. I
Yeah.
have to think I don't think that it would be okay necessarily, but yeah, for that reason, I think
We're going back to fair
yes,
dealing, aren't
Yeah.
we?
So maybe that we need to have a think about that one
Yeah.
further. Yeah, just the last question then. I suppose I should ask myself a question, should I? Well, there's two here. There's two parts to it. So it's with regards to this new section 40B, making works available via dedicated terminals. Does that mean a student can do what they like with that material? No. You're restricted.
They can just view it. They can just
Well,
access.
that's up for debate at the moment. At the moment, you can do it, if the license allows you to do anything further with it, then you can.
Right.
And obviously, you can use it for commercial research or
Right.
private study. Whether you can then do anything additional with it is a question that's up for grabs just now because it's not clear.
You can't copy it.
Well, the question on the table is what can you actually do with the work? So can you print it out? I would very much doubt you could print an entire copy out. I also am very doubtful of the USB plugged in, make a digital copy and walk off the premises, because obviously that's circumventing the exception. So exceptions may be interpreted narrowly, in which case I doubt there's anything other than access. But as I mentioned earlier, this German case will be of interest, and when we find out what the result of that is, we'll let everybody know about it. And lastly, does a terminal have to be in the library? No, as long as it's on the premises. So it might be in your language lab, your IT lab, and so on. So it's a wee bit more flexible than in the library. Okay, I think that's us. We're running a wee bit over time, but it's always good to try and get through as many questions as we can. We're now going to have a roundup of the top 5 things to tell your lecturers. The new copyright regulations are an attempt to update, future-proof and rebalance copyright. As you know, there are significant changes coming your way very soon. To help you share the good news, Jisc Legal has come up with some essential points to tell your staff. Illustration for instruction is a really useful new exception. Provided you stick to the specific purpose and your use is fair, this will allow you to copy all types of work. It's no longer restricted to literary, dramatic, musical and artistic works. The chalk and talk era is fast disappearing, and this exception modernises the law, allowing staff and students to copy using digital technology rather than being limited to copying by hand. So a lecturer or tutor will be able to copy a short film extract and embed it in a PowerPoint, for example, as long as it's for illustration for instruction. Unfortunately, institutions and staff often come across materials which are not accessible to students with disabilities. The exceptions, however, are currently restricted to visually impaired learners and staff. The new law improves things. It applies to all impairments such as dyslexia, which prevent equal access, and will allow institutions to reproduce all types of content in accessible formats, including subtitling. Contract terms will no longer override the exception, but remember it will only apply where there is no commercial copy available at a reasonable cost. There may also still be issues where technological protection measures are in place. For researchers, the new changes mean fair dealing with a work for non-commercial research and private study will cover all types of works. So they'll be able to copy short extracts from sound recordings, films and broadcasts, which they can't do at present. UK researchers will also be able to copy a work in order to analyse it using text and data mining technologies, but the analysis must be for the purpose of non-commercial research, and the person relying on the exception must already have lawful access to the particular copyright work, such as access via their university library subscriptions. It costs libraries a lot of money, time and effort to clear rights in content not covered by the existing law when making a copy of a work in order to preserve or replace it. At the moment, for instance, preservation is restricted to literary, dramatic and musical works, and copying is subject to contract. The new law continues to restrict the exception to permanent collections and only where it's not reasonably practicable to purchase a replacement copy, but it now extends to all types of copyright work, so films, sound recordings and so on will be included. Importantly, any contract term prohibiting or restricting the exception will be unenforceable. At the moment, criticism and review is limited to that specific purpose. This exception has been amended and widened to become a more general quotation exception, which provides more freedom to quote the works of others, to allow you to illustrate a point, or for the purpose of analysis in an academic paper, for example, as long as it's fair, necessary and relevant. Although we've all done it, it's not currently lawful to change the format of copyright works, even for personal private use. The new regulation changes this position. As an individual, you'll be able, for example, to lawfully copy a CD to your personal online storage and then copy it to your phone. You can't give access to anyone else though, and you must keep the original. This exception will obviously prove useful for individual students, lecturers or tutors changing the format of their own personal copies, but it won't go beyond that. So it won't extend to a college or university library uploading all their DVDs to a repository and allowing student access to the digital files, nor will a lecturer be able to digitise a CD and provide copies to students via the VLE and so on. You must still have a licence to do that. These final two regulations on quotation and personal copying will not now come into force in June, but are subject to further scrutiny by Parliament. Jisc Legal will be monitoring their progress, so please refer to our website for further updates.
Well, and that brings us to the last session of this afternoon's webcast. I'm going to say a few closing words. First of all, can I say, well, thank you very much for coming along and participating. We have had a veritable flood of questions and comments, and that is fantastic in feeding into the guidance that we'll be producing over the next few weeks. We'll also do our best to formulate frequently answered questions and the responses that will help you out. And it's nice to know that the questions that we are answering are the ones that you actually need to know the answer to. There's been over 200 of you coming into this session, and that's been a fantastic audience, so I thank you again. And in return, what I can give you is you are the first people in order to know that we have launched our copyright online training package. It is now available on the Jisc Legal website, so you can all run off after this and click on the buttons under the tab training, and then you'll see on the right hand side there's a small registration form so we know who you are and who's using the package, and you can answer it. I hope all of you will get all the questions right at the end of the session. But there you have it, and that's free to use and to obviously distribute amongst your staff and get them up to speed on copyright. So you are the first to know. I'm going to attempt to answer a few final questions, some brief ones. We were asked the disability copying provisions, section 31A, can that be used for academic staff and support staff? And the answer is yes. It's not limited to any type of person or for any purpose, and it's not even limited to educational establishments. It's copying for meeting the needs of a disabled person. Can Section 32, that is illustration for instruction, apply where the CLA licence also applies? So what happens if there's an overlap between the two? There's nothing that stops Section 32 being relied upon in that situation. But of course the existence of a licence will affect the judgment as to what is fair, and Section 32 is a fair dealing provision. And finally, Section 32, can it apply to making materials openly available on the internet? Well, again, the key question is going to be fairness and taking a judgment as to that. To take something that is a password protected or DRM protected material and make it openly available is unlikely to be fair. On the other hand, taking something that is already openly and legitimately available on the internet and making it available again on the internet may very well come under a judgment of fair. With fairness, it's a good idea to get staff to take decisions and to log taking such decisions and to note down in a sentence or two on what basis they consider their use fair. And that way you build up a record of the judgments that are being taken for consistency's sake, if nothing else. I think looking back on today, we've seen that there's obviously many questions with regards to how far Section 32 illustration for instruction will go, and especially with regards to images and that perennial question of whether a lecturer can take an image off the internet and stick it into their PowerPoint slides. And we'll provide guidance on that. There's the question as well as to the interaction between the various exceptions and the licenses that are available, and in particular the blanket licenses that are commonly used. There are questions with regards to accessibility and adaptation and how far that goes, and some questions with regards to the extent to which copyright works can be made available to a larger public or the public at large with regards to libraries and archives and indeed in teaching. As I say, we'll feed all these questions into our guidance that we're going to create and update over the forthcoming weeks. I'll remind you, Jisc Legal, the website contains, hopefully altogether, our materials. We have them ordered by subject area, and so you can choose legal topics and then copyright IPR to find out all the materials we have. We also offer Jisc Legal Plus, which is a training section, if you like, of Jisc Legal, where we come out to you or by video conference can deliver copyright training to your institution. This is on a paying basis. Unfortunately, we do not have core funding in order to carry out the service, but we hope that our prices are pretty competitive and that we can bring the experience of assisting 650 institutions throughout the UK to help you in your institution. Further details again on the Jisc Legal website via training Jisc Legal Plus. What is important to us is you tell us today what has worked, maybe what hasn't worked, and of course important for you is if you fill in the feedback form, you've got a chance of winning a £50 Amazon voucher. There'll be 2 lucky winners, and we'll be making the draw at 4 p.m. a week today. That is the 28th of May. So please do, before you finish up, click on that feedback button and getting your feedback sometime soon. And that brings us pretty much to a close. I would like to take this opportunity to thank all my team that we've had in order of appearance. Deborah Ferns, John X. Kelly, Jackie Milne and Betty Wilder, who have put up with me at fairly short notice devising this idea of a webcast and have gone through the regulations in an awful lot of detail and asked some very good questions and found answers as far as possible to the questions that you need answers to. Back in the studio, back in the office today, Lynn McHugh and Lindsay Gardner have been busy compiling your questions and putting them together and sending them up to us in the studio, so a big thanks there. And also in the background here in the studio, Martin, Craig and Elaine, they have been making sure that all this technology provides a wonderful job in broadcasting out to you, and it's a huge thanks to the University of Strathclyde that hosts us for this facility, and indeed to the people who make it all work. With that, I would urge you to keep on sending in your questions. We have the help desk at Jisc Legal, and we always want to know what it is that's exercising you and causing you trouble, so we can try and help make your job a little bit easier. With that, thank you for your participation, and it's goodbye for this afternoon.